Good evening. I want to welcome you all to the Manges Lecture, which is going to be given by Judge Margaret McEwen. Let me first tell you about the Manges Lecture and Conference Fund. It was established by the law firm of Weil, Gotshal and Manges in 1986 in memory of its esteemed partner, Horace S. Manges, Columbia Law School class of 1919. Generous contributions to this fund were made by Mr. Manges' family, friends, colleagues, clients, and other associates. He was a distinguished trial lawyer and was counsel to leading writers and publishers and to the American Book Publishers Council, which is now the Association of American Publishers, or AAP. A founder, officer, and trustee of the Copyright Society of the USA, he also performed important government service and played an active role in the development of copyright legislation. So let me tell you something about, we're very fortunate to have Judge Margaret McEwen today. She was appointed to the United States Court of Appeals for the Ninth Circuit in 1998. Before appointment, she was the first female partner of Perkins Coie, where she specialized in intellectual property and complex litigation. She holds a JD and an honorary doctorate from Georgetown University Law Center. She was a White House Fellow, serving as Special Assistant to the Secretary of the Interior and Special Assistant at the White House, and also served as a Japan Society Leadership Fellow. Judge McEwen is a member of the U.S. Judicial Conference Judicial Conduct and Disability Committee and has worked extensively on workplace issues in the federal courts. She serves on the Council of the American Law Institute and is an advisor on the restatement of the law for copyright. Judge McEwen has lectured and written widely on ethics, intellectual property, international law, and litigation, and has spent 2 decades working on rule of law projects with the judges and lawyers abroad. Her forthcoming book is Citizen Justice, The Environmental Legacy of William O. Douglas, Public Advocate and Conservation Champion. Judge McEwen is a member of the American Academy of Arts and Sciences and affiliated scholar of the Center for the American West at Stanford University and jurist in residence at University of San Diego School of Law. She has received numerous awards, including the ABA Margaret Brent Women Award of Achievement, the ABA John Marshall Award, the California Bar Intellectual Property Vanguard Award, the White House Fellows Legacy of Leadership Award, and the Girl Scouts Cool Women Award, which is very impressive. All right, so with that, let me introduce Judge McEwen, who's going to give a talk entitled Art, Music, and Mashups, A View from the Bench on Creativity and Copyright.
Well, thank you for that nice introduction. It's really a pleasure to be here at Columbia Law School. I'm fortunate on the American Law Institute to serve on the council, but also the copyright restatement with Professor Ginsburg, Professor Bessick, Professor Balganesh, and others. So excuse me if I don't say it correctly, but for the last couple of years, I've been heavily involved in working with judges and lawyers on rule of law in Colombia. And I realize I am now at Columbia Law School, and I have a hard time getting it right when I'm trying to type that. Now, it's been said that there's little that shapes the human experience as profoundly and persuasively as creativity. But what is creativity? Is it pure originality? Is it divine inspiration? Clever assimilation? Our greatest thinkers have actually given some thought to this, and through the ages, none of them have agreed on what is creativity. To Plato, creative inspiration is divine. Kant, on the other hand, thought that creative geniuses are not divinely inspired, but were born that way. And my favorite is T.S. Eliot. For his part, he recognized the critical role of borrowing in creative work, quipping, "Immature poets imitate. Mature poets steal, and bad poets deface what they talk and take, but then good poets can actually make it into something better, or at least something different." And so let's look then about, well, we won't be looking actually. Supposed to be able to advance. and it's not advancing. Technical difficulties.
Sorry, I will. Did it advanced or no?
Yeah, okay. So I want to say, look what creativity has brought us. Some really wonderful things. But then where does creativity intersect with the law? Well, first and foremost, of course, is in our Constitution, and there it is. And here's what amazes me, that I have this little miniature version of the Constitution. It's only 33 pages long. But in that tiny number of words, guess what gets its own clause? Copyright and, of course, patent. And it's really, I think, quite remarkable. It shows you the importance of arts and sciences, creativity, and invention in the American spirit. But from this critical clause, the American approach to copyright is recognition that it is an engine of free expression. The Supreme Court put it like this. It says the purpose of copyright is to enrich the general public through access to creative works. So this evening I want to share with you how does the law fulfill this notion of creativity, and look at it through the lens of three areas: art, music, and mashups. Now that alone could be probably 12 law review articles, which we don't have time for tonight. So I'm just going to take you on a short journey and offering up some select examples. So before we do that, let me just give you the framework of copyright and copyright infringement. Of course, you need a valid copyright. You need originality. But the Supreme Court has told us that that is amazingly and famously a low bar. You only need minimal creativity. Now, when we think of creativity in a legal sense, it really differs, I think, dramatically from what we think about in a subjective aesthetic sense. Justice Holmes once cautioned and counseled that judges are ill-suited to constitute themselves as the final judges of fine art. And I agree with him, but the reality is that in some respects the law forces us into being an art critic of some sort. But I want you to know that from my view, that unlike that famous phrase in pornography, you know it when you see it, copyright originality doesn't really work that way. The question is often posed, is it inspiration or is it plagiarism? So actionable copying, kind of compressing all the elements, really boils down to access, copying, and substantial similarity. Learned Hand, almost 100 years ago, said it exactly right. He said we have to decide how much similarity is substantial. Well, that's easy to say. But then he went on to say that we're aware as anybody that wherever you draw that line, it might seem arbitrary. And that's, however, not an excuse for not drawing the line, which we're forced to do. And finally, I'll point out that in this copyright construct, that even where there's originality and then there's substantial similarity and infringement, there is an escape hatch, and that is fair use. And you see the elements there. We'll be coming back and talking about those in connection with a number of cases. Here's a perfect example where the Supreme Court gives us what I think is a really elegant way to think about fair use. The court says it's an equitable rule of reason. And the reason for that is courts can then avoid rigid application of the copyright statute if it would stifle creativity. Well, I think that's a beautiful statement, an elegant way to put it. But frankly, finding where is that tipping point is hardly so cut and dried as the Supreme Court might suggest. So on those fair use principles, we look at the purpose and character of the use, the work. Is it commercial? Is it nonprofit? And importantly, among the cases we'll talk about this evening, is it transformative? And then we have these other series which we'll come back to. Now, having given you the 12-second initiation into copyright law, I'm going to give you a pop quiz. So perhaps Professor Besic was a little disingenuous, or Professor Ginsburg, to say, move on down front, you won't be quizzed. You will not be graded, but you will be quizzed. And there is no right or wrong answer, because some of these cases, commentators say, oh, the court was wrong, and in other cases, the court didn't even decide. So, let's go. Quiz number 1. On your left, we have a beautiful photograph by Jacobus Rientmeister of Michael Jordan. Oh, and for those of you who are basketball fans, I assure you, you will be out of here in plenty of time to watch the finals at 9:30 or 9:20 tonight. So that's this beautiful photograph. Nike loved that. They then hired their own photographer to make the photograph in the middle and created this Jumpman logo right from their photograph. And of course, that Jumpman logo has been used in connection with billions of dollars of merchandise sale. So here's your first quiz. Does that photograph in the middle, taken by Nike, does it infringe the photograph that you see on the left? Yes? Infringes? Nobody? Not even a single taker? No? Now you're going to have to get more active here. Okay, now I'm going to move to the Jumpman logo and ask you, does the Jumpman logo infringe that photograph on your left? Yes? Anybody? No? Well, just a few. Obviously, you agree with the Ninth Circuit, which is a good thing, because the court found actually that there were important creative differences here between photo number 1 and photo number 2. And so it rendered them not substantially similar. End of case. Nothing further to be said on that. All right. Now we're going to go to a song. First, we're going to hear a clip from the Spirit Band called Taurus. And now we're going to hear from someone you probably know well, Led Zeppelin. This is Stairway to Heaven. The question then is whether Led Zeppelin, in his composition Stairway to Heaven, infringed that very first song. Let's have a raise of hand for infringement. Yeah? And no infringement? Well, we're going to come back to this, but I will tell you that both the jury and the Ninth Circuit determined that there was no infringement. Okay, this is very familiar for those of you in New York. And me too, because I'm way out west in this, in the Pacific Ocean. So this, as you know quite well, it's a drawing by Saul Steinberg, a cartoonist. It's called The Parochial New Yorker's View of the World. And then on the right, we have a promotional poster for Robin Williams and Moscow on the Hudson. The New Yorker came first, then Moscow on the Hudson. So I'm going to ask you again to put your copyright hat on. Does Moscow on the Hudson infringe that New Yorker cover, magazine cover? Yes for infringement? No for infringement? Okay. This one has actually been decided, and the court found that it was copyright infringement. But as you'll see from many of these cases, there are a lot of judgments to be made, and that's why I'm saying there's no wrong answer here. When the court looked at it, it said, well, look at this. We're looking at this New York block, and it's kind of block by block by block, just the same. We've got the typeface. We've got Moscow in the back here. We've got the Pacific Ocean. But importantly, the court said, this isn't a parody, this Moscow on the Hudson poster, because just parodying the idea of a parochial worldview is not the same thing as doing a parody of the work itself or the New Yorker magazine cover. All right, here we go. The last example we're going to use, you're all familiar with this. In April 2006, a photographer went to the National Press Club and took the photo on the left of then candidate Obama. At the time, Shepard Fairey was a struggling artist, graphic design artist, and he was totally inspired by Obama. So when Obama announced his presidential candidacy, Fairey said, I will create a graphic for you, which he did. He went online, he found the AP photo, Associated Press photo, and then he used Photoshop to create the poster on the right. And his poster really gained national acclaim. I mean, if I didn't show you the one on the left, everybody would say, oh, that's Obama, even if you were to go overseas. Obama was just totally enthralled with this, and he said, your images have a profound effect on people, whether in a gallery or on a stop sign. But I have to tell you, the Associated Press didn't see it quite the same way. They said, no, what this is a form of computerized paint by number, and this is an infringement. So I like this example because it presents a question of originality on that first Obama photograph, substantial similarity, and fair use. But we will never know the answer from a purely legal standpoint, because although there was a lawsuit, after a couple years of litigation, it finally settled. And here's the best part, is that in the spirit of hope, the parties actually agreed to work together to really promote this hope image. So that's the end of that one. And as I say, there's no wrong answer because we don't know the answer yet. But I will tell you, not all copyright cases are actually resolved on a hope and a prayer. So I want to talk then about the first subject, art and creativity. And, you know, we've talked about what is defining creativity. Is it intuitive? Is it something else? But when art meets technology, that even presents a different challenge. So here, I want to go back a little bit in history. 1884, the Supreme Court settled the question of whether a photograph was simply a mechanical reproduction or was it actually art. And the court held that photographer or a photography could be copyrighted, and that in this case there was a photo of Oscar Wilde, that it could be a work of art. But that question of technology versus creativity and authorship has really continued to complicate copyright cases over the years. And the courts have faced challenges ranging from cable TV, file sharing, some of you may be familiar with that, to computer code, metadata, artificial intelligence, and more. But even so, sometimes we see a case with no technical overlay. So we're going to go back to the Michael Jordan case and Rientmeister. In the court's opinion in 2018, the court said, well, first, there's really no question that that photograph on the left is original, and then it went through, and creative, and it went through a whole series of things. But it said most of these are not really copyrightable all on their own. However, when you put them together, that they display an expression that's really in a selection and arrangement of elements. And it was a selection and arrangement that made that first photograph copyrightable and original. Now, the question then really boiled down to substantial similarity. And so the Ninth Circuit found, of course, in the end, that these works were substantially similar. And it talked about how the original photographer had made all kinds of choices, like how to position this kind of ballet jeté, or what kind of shoes, where, the lighting, the location, the nature, of the basket. This isn't a typical kind of dunk the basketball pose that you often see. So just as the first photograph could be creative and original, the court found that the second one could as well. And then went on to say, since that Jumpman logo, all filled in, was nothing more than taken right from that middle photograph, that it too could qualify for copyright protection, but there was no infringement in this particular case. So I want to say that one member of the panel, although this was a unanimous decision, said, in his view, it was not an uncontested breakaway layup to decide that that second photo was actually not substantially similar. And that brings up a question that courts face all the time. We need to filter out, how do we decide? Well, we filter out what's not copyrightable, facts and ideas, but then is there some selection and arrangement that brings it back into creativity and originality? And then there's that question of who decides. Is it going to be a judge or is it going to be the jury? Now, we often, as courts, whether something is within the subject matter of copyright, we usually decide that as a matter of law. But then if there's questions of substantial similarity and fair use, not so easy, and those often go to a jury. Some people will say, how could a jury possibly decide some of these questions, especially as we're going to get into complicated music and other things? We say, well, it's the American way. You have a constitutional right to the jury trial, and juries decide patent cases, which generally are a lot more complicated than many of these cases. Whoops, I'm going to come back to that. So now we go to a case that's very well known here in New York, I think, because much has been written about it. And more recently, I had to change what I was going to say because just a week ago, the Supreme Court granted cert in this particular case. The story is this. The photo on the left was by Lynn Goldsmith, a photographer, and she gave what's called an artistic license to Vanity Fair so that someone could take the photo and make an artistic work out of it for one particular use for a Vanity Fair article. Well, good enough. Warhol did that. What she didn't know was that behind the scenes, Warhol made what's called the Prince series. So not only a series of silk screens, but these little drawings or sketches. Well, fast forward, Prince dies, and now Vanity Fair says, oh, let's get another license and use what Andy Warhol has done. And the photographer says, whoa, wait a second. I gave a one-time license for a one-time thing. What is this so-called Prince series? So, of course, she sues. And it's interesting because the parties both agreed there was no material issue of fact. So no question it'll go to the jury or the judge. It only went to the judge. And the district court said, in fact, that Warhol would win, that there was transformation, fair use, etc. So Warhol wins. Then it goes to the Second Circuit. And the Second Circuit started with the discussion of fair use, which was kind of interesting, rather than saying, are they substantially similar? Maybe that'll knock the case out of the park one way or the other. But what the Second Circuit talked about in looking at these two works is that fair use is supposed to be looked at holistically. There's no kind of bright line. I can't give you a formula. You can't give me a formula. And that all of these statutory factors of fair use are to be used together. But one of the big factors is that second work transformative? Well, the district court thought it was. And the circuit court said, no, you've really used the wrong construct. The district court felt that it was transformative because Prince was in this sort of downtrodden situation in photograph number one, and he kind of got uplifted into something larger than life in that Prince series. And the Second Circuit said, well, that's not the way that you should be looking at this. The overarching purpose and function of these two works is really identical. Not just because they both involve works of art, but their essential sense is that they are portraits of the same person. And they went on to say, we have to be careful not to create a celebrity plagiarist kind of exception. So in other words, well, Andy Warhol is famous, we know he didn't mean to infringe, etc. So we can't give him some like special place in the heaven of copyright. The Second Circuit said that once you get through that first factor and say, this is not really transformative, it is, in the Second Circuit's view, basically a copying, then you look at the other factors. Of course, the first work was creative photograph. Third factor was how much was used. Well, basically they said a lot. What Warhol did is he took that photo and then he overlaid it with the silk screen and other matters. And finally they said there's another factor also very important here, and that is that basically Warhol could destroy the market for this Goldsmith photo. And how could that happen? Well, now she won't be able to license it, or not license it to the same degree. She also would maybe be restricted in what derivative work she might make of that photo. So that then became the overlying principle in the Second Circuit. And interestingly, they then kind of went backwards from how we normally see it, and they said, oh, substantial similarity. If we don't do it on fair use, okay, Warhol also loses on substantial similarity, because basically there is substantial similarity right here. They went on, though, to caution, just because you use somebody's work as the foundation for your work, that doesn't automatically mean it's substantially similar. Then, after the court issued its decision, the Supreme Court weighed in with a completely different case called Google v. Oracle. And some people say, oh, that's the copyright case of the century. And I caution you, it's a very few years we are into this century. So I'm not right. And it may be that Warhol will be the copyright case of the century until another one comes along. But the question here was, the court said that Google had used certain elements in Oracle's Java computer code, but it was transformative and it was fair use. And they were creating these new products with the code. Justice Breyer wrote the 6-2 opinion. And he didn't stop at the beginning and say, well, what's original and what's not? Is this code even copyrightable? Or is there substantial similarity? He went right to fair use and said, well, if there's fair use, end of story, we don't have to go any further. Now, the Second Circuit then was asked to revisit and say, revisit your view, because we think that, at least the Warhol people thought, that this Google v. Oracle was a real game changer, and that, in fact, the circuit's opinion should be overturned. Well, it wasn't. The Second Circuit came back when they were asked to revisit, and they said, no, Warhol is fully consistent with Google. Fair use is highly contextual and fact-specific. So that's where it rested until last Monday, when the Supreme Court granted cert. And there are already 4 amicus briefs in this case. Academics often ask us, and law review editors, do we read their law review articles? Okay, if I'm under oath, I have to say maybe and sometimes. But what I will tell you that we do read the amicus briefs, and they can be enormously helpful, particularly if they don't repeat the original party's briefs. They offer a different perspective. They tell us what will be the downstream consequences of a case, what are the policy implications. So with this in mind, we now have the Supreme Court considering this case. I expect, of course, that it will focus on whether the decision fulfills various copyright policies and goals. And also another thing to consider, that when this case comes to the Supreme Court next term, missing will be 2 justices who've been preeminent in copyright. Justices Ginsburg and Breyer will no longer be on the court. So we'll have to see, will one of the newer or other justices take up this copyright mantle that they have held for so long? And I'd like to pause here to say, look how many judges have touched this opinion or this case so far. One district court, a 3-judge panel of the Second Circuit, 13 judges on the Second Circuit deciding, should we revisit the case en banc? The answer was no. And then on the Supreme Court, 4 justices voted, at least 4, we don't know how many, voted to take the case. But all 9 of them had to look and see, should we take it? Should we not take cert? And then in the end, 9 justices will be making the decision. So all I can say is that a lot of judicial hands have touched the Warhol case, and the final decision we can stand by and see. I want to pause with one note, and that is you can see we've talked about a lot of photograph cases. And why is that? Well, in part because the internet has been a huge proliferation of photographs, and people like to use, copy, etc., modify. But the internet also makes it possible to find out who is using, copying, and modifying. So interestingly, Professor Barton Beebe did a study, and he found that in a recent 2-year period, half of the fair use opinions involved copyrights of photographs, which was pretty amazing. So I want to give you another photograph for just something a little lighter. I'd like you to meet Naruto. He is a monkey who lives, he might still live, in a preserve in Indonesia. And in 2011, a wildlife photographer, David Slater, put a camera out there in the jungle where Naruto lives, and he left it unattended. And Naruto took several photographs of himself, which we now call monkey selfies. But then the photographer said, well, I'm going to make a book of these. And he tried to get copyright protection. And of course, he conceded that the monkey pressed the button. But he said, I set it up, the creativity, the image, and all of that. And the Copyright Office said, no, wrong, because you need to have a human behind copyright in order to get a copyright. And Naruto, cute as he is not a human. Now, later, PETA sued and said, okay, well, if the photographer can't get the copyright, how about Naruto himself? And of course, the answer, this one out of the Ninth Circuit, was no. Once again, we have the situation of we don't have the human element necessary for creativities. So what I can tell you on this is, okay, the monkey can press the button, but he can't press his copyright claim. Now, here's a recent production. This is an artwork completely artificial intelligence generated. And the author, or I should say the creator of this, disclaimed any human involvement. So that should give you a clue as where it might come out in the Copyright Office. The Copyright Office said no. Basically, the nexus between the human mind and creative expression is what you need for copyright. And this was solely machine produced, and that's how you put it forth to the Copyright Office. So the question I raise, of course, is could there be some human authorship that might be produced in artificial intelligence as some part of the work? A little bit different than the author presented it here. So that's something for you all to figure out as we move more and more, and artists move more and more into artificial intelligence. I actually think it's quite a beautiful image. Let me then move from art itself to music and creativity. Here, the court's task, not unlike in art, is to figure out whether there is a protectable work and whether it infringes. Now, that is often highly technical. The court needs to parse distinct elements of musical composition, but it also needs to make that practical determination of, is this a factual issue left for our jury, or is this something that the court ought to determine? So I think that the way courts come down on these questions has significant implications, both for the development of new musical works and for the fair compensation of musicians. Again, we go back to a little history. When the copyright law was enacted in Italy, it was said that Verdi was actually able to amass quite a good fortune. And then guess what? He quit composing, which of course was a tragedy. But Brahms was likewise. He began earning vast sums from his compositions, and then he retired early. So the practical interplay between creativity and then also trying to compensate the creator has continued to be a debate in copyright law. Music copyright has a long and winding history, but two things are clear: that musical scores and sound recordings are both copyrightable. But the economic stakes are high. I don't need to tell you that. So look at the steady stream of music copyright cases. Chuck Berry, Beach Boys, Beatles, David Bowie, Two Live Crew, Rolling Stones, and Katy Perry. The question most recently is, well, does the copyright law extend beyond musical scores and sound recordings? So just 4 years ago, the Ninth Circuit decided a very influential, and I might add controversial, copyright case. According to the case, that court actually created some doubt about the answers to these questions, like how far does copyright extend, because the argument was made that it started to be able to copyright a vibe and sort of a style. So I'm not even going to give you a quiz on this one because you did so well on the other ones, but I do want you to hear. First I'll tell you, this is Marvin Gaye, and what you're hearing from him is his big hit, You Gotta Give It Up. Okay? And now you're going to hear from Pharrell Williams and Robin Thicke, Blurred Lines.
Everybody get up.
Now, one thing I'll say is, of course, we're giving you only a few snippets. And in this case, it went to the jury. They heard a lot more than a few snippets. They heard a lot of also musicologists. But the jury ruled, finding that Blurred Lines had infringed on this gay song. And a divided panel of our court affirmed. There was a jury award of $5 million plus a piece of future royalties for Blurred Lines. But what I found interesting here is that there was a vigorous dissent by Judge Wynn. She said that basically Marvin Gaye gets to accomplish what no one else has ever accomplished before: copyrighting a musical style. Now, of course, the majority didn't agree, but it was interesting because she said she would have resolved the case right up front on summary judgment, arguing that, in fact, these were blocks and building blocks of music that we're looking at, and not something that would really be copyrightable in form, subject to a jury actually having to decide it. So both the dissent and the majority went through a series of things. For example, there was a 10-note sequence in Gotta Give It Up, and then there was a 12-note sequence in Blurred Lines. And the question was sort of the repetition of the notes. What the dissent said is that these repeated notes didn't somehow magically make it copyrightable. And in that, she actually referenced a couple of other compositions. One was Beethoven's Fifth, which we're familiar with. Da-da-da-dum. That's the last time I'm going to sing for you. And Happy Birthday, which I won't sing. But to prove her point, she said those are repetitive songs and sounds, etc. So some of the critics took note of this and said, you know, if the majority is allowed to stand, then copyright law would cover this musical vibe, and it would stop artists from publishing what are legitimately new works, but inspired by other works. So again, that case remains. So I'll bring you another copyright case. There we go. And we're back again to where we started, and that is Skidmore, who happened to be the estate of the author of Taurus, also known as Randy California. So 43 years after the release of Stairway to Heaven, the estate came back in, Skidmore, and said, there's an infringement there. The case went to the jury. The jury found in favor of Led Zeppelin and said the two songs were not substantially similar. At trial, again, it was this battle of music experts, and they were explaining music, composition, arpeggios, and the like. When the case came to our court en banc, I wrote the majority opinion, and I want to point out that this particular case, the copyright had been filed under a previous version of the Copyright Act. And so the jury was not actually hearing the music except as played in parts by some of the experts, but they never heard that side-by-side that I offered you because of the way it came up to the court. But even so, there were several principles that emerged from this case that I think are very important. Skidmore said, well, look, there's five lines that we think are chromatically similar. So they offered up their deposit copy. That's what you give the Copyright Office when you say, here's my work, here's my book, here's my music, here's my whatever. And they said, really, there's these 5 chromatically descending notes from Stairway to Heaven, and you see also those are in the Taurus music. Again, like in some of the other copyright cases, we said, well, musical elements in and of themselves are commonplace, and they're kind of building blocks that are the public domain. You can't take those and own those under copyright. And we gave a couple of examples that were relevant here. The chromatic scales, arpeggios, and there was a short sequence of 3 notes. Again, we said those really are common fundamental building blocks, not protectable. And we also pointed out that this idea of the chromatic scale, or even a minor descending chromatic scale, it's only one of 2 main scales in Western music. So again, you can't lock that up in copyright. In the same way, these couple of chords, in and of themselves, or a couple of notes. So when you have this situation, you might think back to the photograph and you say, well, what about the selection and arrangement? That first sounded pretty original to me. And here's the rub, that Skidmore had failed to argue selection and arrangement at trial explicitly. And although he had offered a jury instruction to that effect, he failed to object when the district court didn't give it. So, like all of these cases, the devil is in the detail. And in trial court, of course, pleadings, theories, and objections matter. And they matter when a case gets up to our court. I'll also say there was one other major point discussed here, the inverse ratio rule, but I'm not going to bore you with that tonight. You can read my opinion, or you can read Professor Boganesh's law review article. I might liken it to the rule against perpetuities and worry that you would all flee if I got into the details. So let me leave the inverse ratio rule for another day. I might add that right after our decision came down in Skidmore, the district court in California was hearing a case about Katy Perry and Dark Horse, a case brought by a rapper, Flame, who claimed that there was infringement. That case is still in the Ninth Circuit, so I won't comment anymore on that. But just to say, it's yet another of these music copyright cases. Here's a song that you're all familiar with, Woody Guthrie's ballad, This Land Is Your Land. So it turns out that this folk classic actually is political commentary on none other than Irving Berlin's God Bless America. And why did he write it? He said that the God Bless America tune just inadequately addressed what was land and wealth inequality in the United States. So he wrote his song, and here's what it was originally called: God Blessed America for Me. And little did Guthrie know that his own protest ballad would later become the basis for one of the very popular riffs in modern politics, and one that its creator said, it's a parody of This Land Is Your Land. So what is a parody? Well, in short terms, it's something that imitates the characteristic style of the author or a work, and it does it for comic effect. So courts have long held that works that borrow from original works to parody them can be transformative and can get that copyright escape hatch. A good recent example was when the author of Wind Done Gone, which parodied Gone with the Wind, the old classic, claimed, of course, parody. So let's take a quick look at this if some of you may not have seen it. Seems like ancient history now.
This land is your land, this land is my land. I'm a Texas tiger, you're a liberal wiener. I'm a great crusader, you're a Herman Munster. This land will surely vote for me.
This land is your land, this land is my land. I'm an intellectual, you're a stupid dumbass. I'm a Purple Heart winner, and yes, it's true, I won it thrice. This land will surely vote for me.
Okay, so I promise you no more quizzes, but I'm really curious because I'm going to tell you that this case never got to be decided. So I'm curious if you think that Jib Jab did a legitimate parody of This Land Is Your Land. Say yes if you think it's a legitimate parody. Anybody? And no? Well, we're not going to know the answer to that yet because Music Publisher had filed a copyright in 1956. But Guthrie actually had filed one 10 years earlier. So the question was, by the time we get here, is it in the public domain? Or does the music publisher own it? And so there were two lawsuits, both of them settled. So we know that they tried Jib Jab to parody, a parody in effect. And we don't know who owns that copyright to This Land Is Your Land. Is it the music publisher or is it you and me because it's in the public domain? But just reminding you that this is another safety valve in copyright. So you go along this continuum. You find out whether it's copyrightable. Then you say, well, substantial similarity. And then you look at fair use and include, is it parody? Is there another out there? So that is, I think, in some ways, a beautiful part of both copyright class and being a court that considers copyright, is that it's like going to a delicatessen where you can eat everything that you want until you're full. And that is how many cases we have. I think the Ninth Circuit has the most copyright cases in the country, followed by the Second Circuit. So these two coastal entities, for obvious reasons, were called the Hollywood Circuit. Of course, you've had a lot of publishing music here in the Second Circuit. So we have this really unending buffet of these cases. Let me then move to mashups and creativity. So this case, how does copyright law deal with it when you actually have clear copying, but also obvious creativity? So I'll bring you a couple of cases to think about. The first of these is Dr. Seuss versus comics. And in this case, Comic Mix. I can never say it right. Comic Mix. See, I can read it, but I can't say it. So here we have the authors of Star Trek pitted against none other than Dr. Seuss. His last book was called Oh, the Places You'll Go, and it always tops the bestseller list right about now. Anybody here graduating from Columbia Law School? Well, you might get this as a gift because it's often given by people to uplift graduates. In any event, the Trekkies were quite enamored by Seuss's children's book, so they wrote their own, And it was called, "Oh, the Places You'll Boldly Go." Now, boldly is a matchup that borrows liberally, quite literally, both graphically and otherwise, from Go and other Seuss works. And what you have is you have Captain Kirk and his spaceship Enterprise, and they're telling the readers, life is an adventure, but it will be tough. Now, the Trekkies never sought a license from Dr. Seuss. And even in court, they didn't really contend that it didn't infringe. But they were somewhat prescient, and here's why. During creation of the book, they said, in their words, that they would be pretty well protected by the fair use doctrine. But they also acknowledged that, as they put it, people in black robes might disagree. And indeed, we did. So, as in Warhol, our court examined the fair use question really through the lens of these 4 factors. But keeping in mind, I'm going to show you a couple of examples, but we're looking at the whole book, and we're looking at the side-by-sides, and we're looking at all of the documents. And you're only going to get the benefit of a snippet. So I'm not asking you to make a judgment based on that snippet any more than truly I was asking you to make a judgment based on our other snippets. But the first thing we said is that boldly, that is the Trekkies version, was not a parody. It wasn't commenting on Dr. Seuss's work, but it was retelling it with very similar, if not more than substantially similar figures. So we said it was really to get attention, or even basically to bypass this creative process. So we also determined that it wasn't transformative. And part of that was looking at how the Trekkie version of Boldly actually just repackaged the Boldly You'll Go Dr. Seuss images. Here's a good example. This is called The Machine. And these illustrations are really virtually identical, color, shape, even down to the detail of the squiggly. Now, in the Dr. Seuss version, which is on your right, the Seussians are going in and out of this machine, and in the left we have the Trekkies going in and out and being shot out in the same way. So the copying was obvious, and there's also text to go with it. Transformation was not obvious. Another example. So here we have the waiting place, and you can see how the Trekkies, which you can see on your left there, they have the same waiting place with different people. They have the same fishing, they have the same trees, the same everybody lining up for the outhouse, etc., even the placement of the couch. So to this, they just added, in effect, Star Trek characters who line up and sit on the couch. And so, in our view, they basically had not transformed Dr. Seuss's work. And there's plenty to parody, we might add, in Dr. Seuss's work with some of his messages and indeed some of his illustrations. So ultimately, here's what we said. Although the Trekkies' work need not boldly go where no one has gone before, its repackaging, copying, and lack of critique of Seuss, coupled with its commercial use of the Go manuscript, did not result in a transformative use. So that weighed very heavily against the boldly. And we then went through the remaining statutory factors. But when we got also to how much of the work was used, well, basically close to 60%. It wasn't some here and some there. Each of these highly imaginative illustrations was really used in large part, down to particular composition and arrangement and visual elements. So what we know is you can't just add something on top and then say it's transformative or it's a parody when you're not actually going after Dr. Seuss. You want to get on his train here and get into that graduation market. So it may be that you could get a copy of Boldly floating around on the internet if you want to take a look at it, or look at parts of it in the record. And I'll come back and emphasize that I'm only giving you snippets to get a sense of these copyright cases, but we're really looking at large records, we're looking at testimony, and we're looking at experts. So let's go to another example, and that is sampling. This, of course, you're all familiar with. It's the art of taking a sound bite from an existing song and then creating a new composition. And we know that it dominates hip hop and rap. I think one industry insider put it this way: old recordings are to hip hop producers what paint is to the painter, raw material to be manipulated into art. So let's just listen to a sampling example. Listen first to that first composition, and then you'll see it moving in to the other compositions.
And the
We've come a
And the-
long way together, through the hard times and the good. I have to celebrate you, baby. I have to praise you like I should.
Okay, so this kind of sampling, which you hear a lot of these days, it forces courts into this uncomfortable position of saying, well, is 25 seconds too much? How about 1 second? Or even a 1 second beat that lasts longer than a quarter of a second in the sampling. So the answer to that has created a rift in the circuits. And the Sixth Circuit has a very easy bright line answer. Get a license or do not sample. Sort of another version of get a life or do not sample. The Ninth Circuit has seen it a little bit differently. And we've said that the de minimis exception applies in other copyright contexts concerning copyrighted sound recordings, and so it applies the same here. So we're not going to make a carve out from music sampling and treat it differently. Now, this kind of split has garnered quite a bit of commentary in art and legal circles. Critics of the Sixth Circuit decision say that you basically are going to stomp on creativity if you don't permit this kind of small amount of sampling that's then merged into something else. In fact, one of your professors here, Tim Wu, has said that the costs of the Sixth Circuit's bright line rule vastly outweigh the benefits because of the pervasiveness of sampling in rap and hip hop. The Sixth Circuit, of course, would disagree with that, and they say, well, just go into a music studio, recreate the sound on your own, however you want to recreate it, sample yourself, and then come out with your sampling. So I think it's a very interesting split, and I think it will be only a matter of time before ultimately the Supreme Court needs to resolve this matter once and for all. So where does that leave us with this series of snippets, films, and others that you've seen? Well, from the court's perspective, I want to emphasize how important the record is. That in each of these cases, we look very carefully at the record below. And the record below is so important to us, not only for the testimony, or for the sound bites, or for the graphics, but how does it all fit together? So that's the first thing. The second thing is that we're looking in these cases, are there building blocks, whether it's in the photography arena or music, that really can't be kind of locked up and kept out of the public domain, because the reason? That would stifle creativity, which of course would be against the whole purpose of copyright. The other thing we look at very carefully is maybe there's a selection and arrangement. Creativity comes in all kinds of forms. So it doesn't have to be right out of the box kind of genius creativity, but you can take common elements, put them together in a very interesting way. You select and you arrange, and you too can have a copyright. The other decision we make very carefully is it going to be a jury or not a jury? And then finally in this very, what's called the billowing goo or like a fairy tale of fair use, we, like the Second Circuit, step back and we look at everything holistically. In a way, we're not archaeologists who are trying to dissect the work into its tiniest little pieces and then see what can be put back together again. We're really trying to look at the work as a whole, although we do need, of course, to see are there protectable or non-protectable elements. And then finally, we often come down, as the Supreme Court counsels us, to looking and seeing whether our opinion, the way we come out in a case, actually advances the reasons and the principles of copyright that the Supreme Court has laid out. So now we come full circle. We're back to the monkey and the fabulous AI drawing. And it's full circle from the time that copyrightability of photographs was up in the air and in question. And Congress at that time stepped in and said they could be copyrighted, and the Supreme Court confirmed that. So we then went forward many years, and people were wondering the same thing. What about computer code? Well, courts had dabbled in that, but then the Congress stepped in and said, you can copyright computer code. So you might say to yourself, well, if you can copyright computer code, why not a depiction derived from artificial intelligence, which didn't just come out of thin air, but needed some human element of creativity to create parts of the artificial intelligence? Well, the question we have, because we don't know if Congress will step in or this will just remain where we are, that AI is not copyrightable. But the question is, and one for you to think about, is there some slice in this needing a human element that can intersect with artificial intelligence? So is there a way to fit it in? Over the past 2 centuries of copyright, there has been this fascinating dance between the courts and Congress as to the scope of copyright, and it's occasioned often by advances in technology. So as we sit here today, we might think AI is an advance in technology, but we have no idea what else is coming. But what we are, I wouldn't say stuck with, but what we're bound by, of course, is the Copyright Act. So meanwhile, in courts, we accept that Congress has provided us this basic framework for copyright, but it's very minimal in many respects. So it's the courts that are putting the meat on the bone, and often we know that these answers are far from clear. We are not art critics, but we still need to retain the force of critical analysis and critical judgment. And we can't simply take the legislative factors or even factors that other courts have come up with and just use them rotely. We need to be very thoughtful about how we're thinking about how we go from the copyright law to the application of the copyright law. One thing is true, creativity remains paramount. So I invite you to become part of the discussion and, I hope, the solution of the next generation of innovation and creativity. Thanks for having me. I can take a few questions, she tells me.
You don't have to.
No, I'm fine. I'm fine if somebody has a question.
All right.
Yes?
First off, to go along with your existing copy of the Constitution, I have one here for you that's actually signed by the author, which also happens to be a mashup, Constitution Illustrated.
I love it.
I thought you might. Now, regarding Seuss versus Comic Mix, first off, hi everybody, I'm Glenn Howman, I'm the head of Comic Mix.
And that's why he knows how to pronounce it.
Yes. Now, I'm happy to have a discussion with it, whether it's transformative or everything else, but not here. I'm happy to discuss that outside. That's not even the course of this discussion. But in your ruling, specifically with regard to the fourth factor, in your ruling on, I realize I should actually be recording this. Sorry, I should have the microphone on so people can hear me. You bring up a question in the test in the fourth factor that you say that it is incumbent on, in this case, us, to prove that there is no market harm. in the fourth factor. That was in the ruling. And you give no guidance as to how we are supposed to prove that there is no market harm. How we are supposed to have insight into a private company's financials, a private company's separate licensing agreements, a company that in fact still has redacted material in the court cases so that I can't even see, their material. How am I supposed to prove a negative? How am I supposed to prove that there's no harm? In particular, also because, and actually I came across this in an article that you wrote with regards to, with copyright law and the patent material that had been coming over, that there's no longer a presumption of irreparable harm in copyright. So how am I supposed to prove that there is no harm, particularly when there's already a presumption that there's no harm?
I couldn't hear what you said.
Sorry about that. My apologies. Speaking of artificial intelligence.
Thank you for the question. I'm not going to answer that question with respect to Dr. Seuss. Opinion is issued.
Yes, it is.
And of course, as you know, we do not then go behind those opinions. But let me make a couple comments. First, there was always some confusion about this market and how was the market affected by the allegedly infringing work. And what has now been established is we know that fair use is a defense. And there are several elements of fair use, although not confined solely to that. But as a defense, then, the defendant has the burden to do that proof. How might that happen? Well, I would think back to my days as a lawyer, not as a judge, and I would say that, there are experts that are very good at looking at markets. There are also comparable other companies that have similar situations. So there are a lot of different ways to provide proof of this nature. And while some might say, well, it might be difficult, there's, of course, depositions, there's documents, and, of course, putting all that together and presenting it to the court. And if somehow someone were to say, well, my hands are tied, there's nothing I can say on this point, then that's what you would argue to the court. But it is not an impossible task, and is one that really fits with the way we look at burden of proof for defenses in typical civil procedure style. Thank you. Yes?
So you talked about a number of different kinds of works tonight. And I'm curious, when you think about fair use, are you looking for a unified theory of fair use? Or do you think that specific works have, sort of a different way that fair use applies? I'm thinking specifically about in the Warhol case, the Second Circuit was reacting to Cariou, the prior case, and trying to figure out how do we do this in photography? And as you said, we have the Google case coming in, and now the Supreme Court's taking it up. Are there lessons we were supposed to learn from a software case in a photography case? Are there lessons the other way? Or is it really take the cases as they come, and each fact pattern will be its own fact pattern?
Well, the first...
Oh, and I'm sorry, I'm Joshua Simmons from Kirkland and Ellis.
Great, thank you. The first thing I would say is come back next year, and then I will talk to you about what the Supreme Court had to say. But one thing that comes to mind when the Supreme Court says this is context specific, I'm thinking, is it Bush v. Gore, which is in some ways what the court said there. And I think what the court means by context specific, and the Second Circuit repeated that as well, is that you do have to look at the works at issue here. And so how is it the Supreme Court is going to integrate Oracle v. Google into Warhol? Well, I don't know. We're going to have to stand by. But one thing I thought was particularly interesting about the Second Circuit case, and it's something that we see across the board, they had one particular photograph case, and they repeatedly went back to that to say, this is how it's different. Our case is different. This might be similar. This is different. And of course, that is what is the foundation of stare decisis and precedent. And I think that when courts are looking at something, it might be a new context to them. So we're always looking for an anchor in the past. And you'll see that particularly in copyright cases. Sometimes you might say, but this isn't that, or this doesn't fit into that construct. And the court's free to deviate, not to change precedent, but to apply it in a way to the particular context. So I think that's why you saw the Second Circuit continuing to look at what precedent it had. It had this big photograph case. We now have several photograph cases. The Second Circuit said, well, this isn't like Rientmeister. Rientmeister went out and Nike took another photo, and then they made Jumpman, and that's not this. Well, that's true. That was not this. This was not Warhol. But I do think that it sort of shows you the way that courts think about things. And of course, a panel of any court is bound by the precedent of that court, absent an en banc rehearing. And while we have cases are reheard more commonly in the Ninth Circuit than the Second Circuit, I would still say out of the thousands of cases that are heard every year, that the opportunity for a complete rehearing is actually very small. So with that, no?
Then let me invite everybody to, we're having a reception upstairs, and I hope everybody will come. It's on the 7th floor in the King's Lounge, so when you get out of the elevator, you make a left turn, and we'd like to see you all up there. Appreciate it very much. Thank you so much.
Well, thank you. You're a great audience, and if you have some better answers to the questions, come forward. I'd like to hear them. Thank you.